Start. The second respondent made a claim in case number MSEFC/CBER/111/2021 before the first respondent under Section 18 of the Micro, Small and Medium Enterprises Development Act 2006 in bracket hereinafter referred to as the MSMED Act for short, for payment of rupees 86,89,416 from the petitioner towards the value of goods supplied with interest calculated in terms of that act, in which an order dated 25/2/2022 was passed holding that the petitioner was liable to pay the sum of rupees 86,89,416 together with compounded interest with monthly rests at 3 times of the bank rate notified by the Reserve Bank of India as stipulated in MSMED Act from the invoices dated from 9/12/2022, 4/5/2021 till the date of realization of dues, which is assailed in this writ petition. Learned counsel for the second respondent has raised preliminary objections regarding the maintainability of the writ petition by contending that if the petitioner is aggrieved by the impugned order, it has only to resort to filing of an application under Section 34 read with Section 2 subsection 4 of the Arbitration and Conciliation Act 1996 in bracket hereinafter referred to as the ANC Act for short, to have it set aside as an arbitral award, and that in any event a writ petition to set aside an arbitral award cannot be prosecuted without complying with the requirement of pre-deposit of 75% of the amount involved in terms of Section 19 of the MSMED Act. In response, learned counsel for the petitioner contends that when the first respondent has not conducted the arbitral procedure as required to be followed under the ANC Act read with MSMED Act, the petitioner is justified in invoking the plenary jurisdiction of this court under Article 226 of the Constitution to impeach it, placing reliance on the decision of the Honorable Supreme Court of India in Jharkhand Arja Vikas Nigam Limited versus State of Rajasthan in bracket order dated 15/12/2021 in civil appeal number 2899 of 2021 and the decision of the division bench of this court in Messrs. Superstream Boilers Engineers Private Limited versus Micro Small Enterprises Facilitation Council, Coimbatore region in bracket order dated 7/3/2022 in WA number 2655 of 2021. In that regard, it is further submitted that the requirement of pre-deposit of 75% of the amount involved as stipulated in Section 19 of the MSMED Act cannot be made applicable to writ petitions under Article 226 of the Constitution as held by this court in the decision in Srivalli Process versus Micro Small Enterprises Facilitation Council in bracket 2022 5 MLJ 489. The pivotal question that arises for consideration in this case is whether a writ petition under Article 226 of the Constitution could be entertained to challenge the order passed under Section 18 of the MSMED Act, and if so, whether the requirement of pre-deposit of 75% of the amount involved as required under Section 19 of the MSMED Act would not be applicable to such case. At this juncture, it must be noticed that Section 34 subsection 2 class 5 of the ANC Act provides that an arbitral award may be set aside by the jurisdictional court on an application made by the aggrieved party when the arbitral procedure is not in accordance with the provisions of that act. It must at once be emphasized that the Honorable Supreme Court of India in Assistant Collector of Central Excise versus Dunlop India Limited in bracket 1985 1 SEC 260 has precisely explained the legal position relating to the exercise of discretionary powers under writ jurisdiction when an alternative remedy exists in the following words. Article 226 is not meant to short circuit or circumvent statutory procedures. It is only where statutory remedies are entirely ill-suited to meet the demands of extraordinary situations, as for instance where the very wires of the statute is in question, or where private or public wrongs are so inextricably mixed up, and the prevention of public injury and the vindication of public justice require it, that recourse may be had to Article 226 of the Constitution. But then the court must have good and sufficient reason to bypass the alternative remedy provided by statute. Surely, matters involving the revenue where statutory remedies are available are not such matters. We can also take judicial notice of the fact that the vast majority of the petitions under Article 226 of the Constitution are filed solely for the purpose of obtaining interim orders and thereafter prolong the proceedings by one device or the other. The practice certainly needs to be strongly discouraged. In Nivedita Sharma vs. Cellular Operators Association of India in bracket 2011 14 SEC 337, adverting to the previous decisions with regard to the rule of self-restraint when an alternative remedy is available to the aggrieved person, the Honorable Supreme Court of India has emphasized that when a statutory forum is created by law for redressal of grievance, a writ petition should not be ordinarily entertained, ignoring that statutory dispensation. Further, the law has been